All right, we're on the record in the case of Nicholas Ravello versus, and is it pronounced Karen or Karen?
Karen.
Karen. Sangalaza, and this is a child custody complaint set for an evidentiary hearing / trial today. Appearances for the record.
Good morning, Your Honor. Sean Lytle, 11640, on behalf of plaintiff Nicholas Ravello, who's present.
And you're Ms. Sangalaza?
Yes.
And you're representing yourself, is that correct? Okay. Very good then. You can be seated, and so can Mr. Lytle. I just want to, and you don't have to jump up every time you address me. If you wish to do so, that's fine. But I read the pretrial memorandums, and I read the previous minutes and orders in the case. And so this is an evidentiary hearing to determine the custody arrangement. The custody arrangements that were previously ordered by Judge Gentili and Judge Marquis were temporary orders, not permanent orders. They were intended to be the orders in place only until the trial today, so this would be the trial on what the permanent orders would be. So at this point, Mr. Lytle, are you seeking joint, primary, or sole physical custody?
We're seeking sole physical custody.
All right. And Ms. Sangalaza, you had discussed both primary physical custody and sole legal custody, or excuse me, physical custody. Which do you wish to, are you planning on pursuing today?
Sole custody.
All right. So for the record for both of you, the Nevada legislature has created a presumption that joint physical custody and joint legal custody is in the best interest of a child. In order to overcome, each of you has the burden, respectively, to overcome that presumption, okay? Which means that you have to present evidence that convinces me that it is not in the best interest of the child to award joint physical custody, and that one of the two of you should either get sole legal custody or primary physical custody, with the other parent having certain visitation. I will also note that asking for sole physical and sole legal custody is an extremely high burden, because it is an equation by the Nevada Supreme Court almost with termination of parental rights. So rarely does a court award that, and that would require proof by very significant evidence. So I'm just letting you know that that's the standard that you would both have to comply with. So with that in mind, are there any preliminary matters you'd like to raise with regard, Mr. Lytle? I'm not going to have opening statements because I want to save most of the time for testimony. So, and I did read your pretrial memorandums.
Okay. We're not going to do opening statements. That's fine. I did want to figure out what we're going to do in terms of, well, I sort of have two housekeeping matters or questions. The first involves the fact that, excuse me, there are only, Ms. Sangalaza has only identified 3 witnesses, one of whom is herself. Obviously, she's entitled to full participation in these proceedings.
Can I object to that? I have
One moment. I think she identified actually 3 in addition to herself.
Correct. I stand corrected on that. Two of those 3 additional witnesses are her parents, who we had sought to depose in this case the day before their depositions were to go forward. We received notice that they would not be participating in those depositions. This was right on the eve of what was to be calendar call for the previously scheduled trial before the case left Judge Gentile's department. I'm not sure exactly what the nature of their testimony would be, but I would like to impose some restrictions on their ability to offer direct testimony in light of their refusal to participate in duly noticed depositions. So that's question one. And then question two, or issue two, I guess, is because Ms. Sandovalza is representing herself today, I'm not entirely sure. I don't want us to get bogged down on a number of objections in terms of her questioning of our witnesses. And so I'm wondering if the court would be willing to entertain some sort of standing objections with respect to certain lines of questioning so that we can keep things moving today. I'm just not sure what the court's preference is on that particular issue.
So,
And then I respond.
hold on for just a moment. So the first issue is that he's asking that your parents not be allowed to testify because they failed to appear from the deposition after being noticed of the deposition. So that's the first issue that you would need to address. That would not prohibit him from calling them as what is known as an adverse witness, or for you calling them to rebut testimony that was presented in his case in chief. But that's what his request is. So now you can respond to that, and then we'll deal with the second issue.
Okay, so the first issue, when it comes to the deposition, at our house, we received the depositions about less than 2 weeks before we were supposed to appear. My parents already had plans to be out of town. They were not, they were out of town, and they sent, they emailed they emailed and they emailed a letter saying that they were unable to. I personally, that was my first week of classes, so I had to deal with financial aid. I already had appointments with financial aid, and I had appointments with my professors. So, I mean, you can't send out, you can't request
How soon after you received the notice did you send the information that you would not be available on those days? How do you?
The day before we were supposed to go, we emailed the letters. But because there's no timeline that says we have to, respond to that type of notice in a certain amount of time. We were given that notice less than 2 weeks before we were supposed to appear.
Okay. So the first thing is the notice was adequate. That's a reasonable period of time. If you had conflicts, the wiser thing to do is not to wait till the day before to notify the parties, because then they don't have a chance to reschedule for a time period when you might be there. However, I am not going to employ a sanction that prohibits your parents from testifying in your case in chief, that is when it's your turn to present your evidence, but it may, you're not attending the deposition and they're not attending the deposition. Mr. Lytle is free to argue how that affects credibility. Okay? The second issue, Mr. Lytle, is that to enter a standard objection to certain topics without you telling me what those topics are, no, I cannot do that. So if you want to object, and I sustain an objection for particular reasons, and then, and this is true of either side, then you don't have to keep objecting if it's the same issue. I'll simply note, no, I already said you can't ask that question to either one of you, or that the witness can't give that answer to either one of you, depending on what it is. Because you are representing yourself, there is a certain amount of job that I have as a gatekeeper of the evidence to ensure that the trial is evenly placed. That simply means that if something is obviously objectionable under the rules of evidence, and you don't object, same thing is true, Mr. Lytle doesn't object, I do have the authority to say, no, that's hearsay, for example, and I don't see any exceptions, this is the technical way to phrase it, to the hearsay rule, so I'm not going to allow that question to be asked, and any part of the answer that started to come out before I started speaking would be stricken, and that applies to both of you, okay? And there are rules of evidence, though, and I cannot simply relax them because one party has an attorney and one party does not. Okay? All right. Anything else that's preliminary, Mr. Lively?
No, Your Honor.
Any other preliminary matters that you'd like to raise?
Yeah, I'd like to open the courtroom for people to be able to observe it and see what's going on.
Well, if you have people who are going to be witnesses, they're not allowed to be in the courtroom while they're testifying.
Non-witness.
You know, is there someone that's a non-witness that you want in the courtroom? I mean, they would not then be able to discuss the matter with you or anyone else. In other words, that person goes out and starts talking to your other witnesses, that would cause those witnesses not to be allowed to testify. So, and that person would not be allowed to testify themselves if you suddenly decided that something came up that you would want that testimony. Is there?
Right, that's fine. Yeah, no, that's fine.
I just wanted to make sure. You still want somebody in the courtroom that's, okay, and who would that someone be?
Mr. Steve Stanson.
Okay, and he's just your friend, or,
Yeah.
okay, and,
Your Honor, we're going to object to that. Mr. Sanson operates a website, Veterans in Politics International. He's already been sort of weighing in on this case publicly and making disparaging statements about parties, counsel, and judges involved in this particular matter. And there is absolutely no legitimate basis for him to be in the courtroom today. We're talking about a very young child, not even 2 years old yet. And I would ask that, with the exception of the witnesses as they are called, that the courtroom be closed for today's proceedings to outside observers.
on what basis do I have to close it to the public?
Again, because we're dealing with a very young child here and we're dealing with some very sensitive issues, and because with this particular witness there is a history of basically in real time, commenting publicly about what's going on in the courtroom.
One cannot report from the courtroom. Is that your concern?
That is my concern. Yes.
If he can certainly watch, but he cannot report from the courtroom, which
Absolutely.
means that his electronic devices need to be lodged with the marshal.
Absolutely, Your Honor.
Okay, that would be appropriate, so you can ask Mr. Sanson to come in under those conditions. Okay. So you can allow him to come in, and I'll let him know what those conditions are, and then he needs to give his communication devices to.
Thank you, Your Honor.
Mhm.
He's no longer outside.
Oh, okay. Very good. Then in that case, we'll go ahead and we'll start with the witnesses, and if you'd call your first witness, Mr.
Thank you, Your Honor. Call Nicholas Rubello.
Okay.
You can remain standing with your right hand to be sworn.
You do solemnly swear testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning, Mr. Rubello. Could you please state and spell your name for the record?
Nicholas Charles Ravello, Nicholas, Charles, Revello.
Thank you. And you are the plaintiff in this action, correct?
Yes.
All right. And we're here today to discuss custody for your son, correct?
Yes.
What is your son's name?
Julian Samuel Ravello.
Okay, and how old is Julian?
Just about 19 months.
Turned 19 months yesterday, correct?
Yeah.
Objection, reading question.
It's not asking for significant information that isn't already part of the record, so I'll overrule the objection.
All right. And Julian's mother is also a party to this case, correct?
Correct.
And what is her name?
Karen Sangalaza.
And she's the defendant in this action?
Yes.
Okay. And you see her, she's present in the courtroom today?
Yes.
Okay. I'd like you to tell the court how and when you met Ms. Sangalaza.
We met in the summer of 2017, I think in June, here in Las Vegas.
And did you pursue a relationship with Ms. Sangalaza?
Yes.
What was the nature of that relationship? Was it friendship or something more significant?
Yeah, we started dating as soon as we met. We were inseparable, spent every night together for many months.
And how would you describe the relationship between you and Ms. Sangalaza in the summer of 2017?
A lot of fun. Yeah, very positive.
Now, at some point, Ms. Sangalaza became pregnant, correct?
Yes.
With your son Julian.
Yes.
Okay. When did you find out approximately that she was with child?
We found out in late August after we had moved to Wisconsin together.
Okay.
Of what year, sir?
2017.
So later in that same summer.
Yeah, about 2 months after we met.
Okay. And what was your reaction to the news that she was pregnant?
I was shocked.
Shocked in a good way or in a bad way?
In a, this is very unplanned sort of way.
Okay. All right. Did you make any plans with Ms. Sangalaza as to how you were going to proceed with the relationship, if at all?
Well, we were living together at the time, and we were dating with no signs of stopping. And once she was pregnant, I thought any decisions regarding the child should be up to her
Okay.
at that point.
Meaning what?
Meaning if we wanted to pursue raising the child or other avenues like, I don't know, adoption, I wanted to let her make all those choices.
Okay. And you said you were living in Wisconsin at the time?
We were at my home in Ripon, Wisconsin.
When did you move to Wisconsin?
It was probably early August of 2017.
And it was after you had moved to Wisconsin that you learned of the pregnancy?
Yes.
Okay. When did you meet any other members of Ms. Sangalaza's family?
I don't recall if I met them that summer. I know I did spend Thanksgiving of 2017 at their home in Las Vegas.
Okay. Were you still living in Wisconsin at the time? Did you travel back for that, or?
Yes.
Okay. So her family was living still in Las Vegas. You were living in Wisconsin with Ms. Sangalaza, and you traveled back for the Thanksgiving holiday in 2017. Is that what you said?
Yes.
Okay. Was there discussion of her pregnancy at that Thanksgiving gathering?
Everyone was aware, as far as I know.
And what was the reaction of her family to the pregnancy?
They seemed supportive.
And when we're talking about her family, how many people are we talking about?
Her family at that time was living in North Las Vegas. It was her mother and father and her two siblings, Isabel and Barrett.
Okay. So it's a sister and a brother?
Yeah.
was there discussion with her siblings about the pregnancy at the Thanksgiving gathering?
Objection, leading question.
The question is,
It was already
calls for a
asked.
yes or no answer. So I don't think that it's leading, but the issue, all right, just a moment, we'll take a break. Mr. Sansone, I assume, from your t-shirt?
Justice Becker, how are you?
All right, I'm fine. I have indicated that you may be in the courtroom, but you may not do live reporting from the courtroom. So if you have any, a cell phone or a tablet, if you would,
No, ma'am.
okay,
I know the rules, ma'am. Thank you.
that's fine. I just wanted to let you know.
Thank you, ma'am.
All right. Please proceed. I'm sorry. The objection was on leading, so I overruled it. But the issue is just whether or not you had discussions, not what those discussions were.
Yeah, her entire family was well aware that she was pregnant.
Okay, all right. And I think you said that her parents were supportive, were her siblings supportive as well, or?
It seemed that way. yeah.
Objection, leading question.
Sustained?
Okay. What was the reaction of her siblings to the pregnancy?
They seemed fine with it.
Okay. All right. Where and when were you, or where were you residing when Julian was born?
A couple months before he was born, I moved our family out to Las Vegas because Karen was back in school and living with her parents. So I came out and rented an apartment. We were all living together. So we were living here in Las Vegas when he was born.
Okay. And were you present at Julian's birth?
I was. I drove his mother to the hospital.
Who else was you said the hospital, which hospital?
Summerlin Hospital.
And who else was present at Summerlin Hospital when Julian was born?
His mother's parents and her friend Bree and myself.
All right. So, you said earlier that the relationship prior to, or in the early days was, I think you said fun, right?
Yeah.
So we just, okay. After Julian's birth in April of 2018, how would you characterize the relationship between you and Ms. Sangalaza?
Abusive.
Can you elaborate on that?
For the 3 days we spent in the hospital after he was born, she didn't sleep, and neither did I. I was staying awake to allow her to sleep, and she verbally abused me for 3 days straight, including threatening to leave me off the birth certificate.
Did she leave you off the birth certificate?
No,
So you are identified as Julian's father on the birth certificate?
I'm definitely his father.
Okay. So at the time, you and Ms. Sangalaza were living together in an apartment you rented here, correct?
Correct.
Okay. Is that the apartment that you took Julian home to when
Objection,
you left the
leading
hospital?
question.
Sustained?
Where did Julian first live when he was born?
I wanted him to live at our apartment with myself and his mother, but her family insisted that they go to live in North Las Vegas. And they put him in their car and left without our consent. They essentially kidnapped him right from the hospital.
Who all went in the car with them?
Her mother, her father, and her, and the baby.
Her meaning?
Julian's mother, Karen.
Okay. Okay. Did you receive any communications from Karen and or her parents after they left the hospital?
Yeah, we were communicating.
by text message?
Yep.
Objection, so leading question.
It's foundational, I'll allow.
May I approach the witness?
You may.
Mr. Rebella, I'm handing you a stack of proposed exhibits for today's proceedings, and I'd like you to look at Exhibit 1.
Your Honor, can I object? I've never even seen, I was not sent a copy of these exhibits. I didn't even know that they had any exhibits. On their pretrial memorandum, they listed that they were just going to use the exhibits that were already entered and the talking parents' messages. Exhibits that were already entered were my own exhibits, if you look back in there.
These exhibits were
One
previously.
moment. So the pretrial memorandum indicated that it would use the exhibits that had been previously attached, they were never admitted,
Correct.
previously attached to the parties' pleadings, either ones. So that's what he indicated. Did you send a copy of the exhibits to her, Mr. Lytle?
Of this particular arrangement of the exhibits?
Were the exhibits produced to her at any time prior to this proceeding?
Well, again, so for example, Exhibit 1 that I'm asking him to look at right now was attached to a counter motion that was filed very early on in this case, and it was discussed at length in court.
Okay. So the first thing is to have him identify exhibit number 1, and if you look at it, ma'am, if it's a document that was previously attached to a motion, then you would have had notice of it from the pretrial memorandum. Okay? You absolutely, you take the time to take a look.
Your Honor, I'm going to object to this first exhibit because I don't have any recollection of it ever being submitted, anything ever. You know, these are screenshots of a phone. Yeah.
Okay. Mr. Lytle, what pleading do you allege that they were attached to?
Attached to our opposition and counter motion. Opposition to motion for temporary primary custody, counter motion for temporary sole physical custody, filed on August 7th, 2018.
Okay.
They were Exhibit A to that particular filing.
All right. Why don't you continue to lay foundation while I double check and see whether or not that is. Okay, so it was the clerk doing that. I think the clerk is doing that for me, am I correct, Mr. Clerk? All right, so he is double checking,
Thank you, Your Honor.
and you can lay the foundation.
All right, so have you looked at Exhibit 1?
Yeah, I screenshotted it.
Okay, and could you identify what Exhibit 1 consists of?
It's a text exchange between myself and Karen. And do you know when this text exchange took place approximately? Approximately June of 2018.
Can I object to that?
One moment, the clerk has just indicated that the clerk has compared page by page the proposed exhibit number 1 with attachment A to the pleading, and has, it's A and B apparently to the pleading, and confirms that the documents marked as proposed exhibit number 1 are the same documents that were attached to the pleading in August of 18. Now, you have another objection?
Yeah, I mean, there's no time or date. There's a time stamp, but there's no date stamp. The witness claimed June
that would go to the weight to be given the exhibit, not necessarily
There's a
its
date stamp,
admissibility.
Saturday, June 30th, 10:58
One
a.m.
moment, sir.
Okay,
We haven't asked you
all
the
right,
question.
sorry.
All right, Mr. Lytle, if you continue to lay foundation, please.
Thank you. I'd like you to go to the third page of Exhibit 1. Just for identification purposes, at the top in the center says 8:11 a.m. You see that page?
Which page, sorry?
The third page. At the bottom right corner it says 1 of 1, but there's a few pages that say 1 of 1, so.
Okay,
I believe this is what you're referring to at the top of that page. Did you say there is a date stamp?
yes.
And what does that date stamp say?
Saturday, June 30th, 10:58 a.m.
Okay. And on this particular page, these messages, are these your words or the defendant's on this page?
These are my words.
Okay. So that first entry that's stamped June 30th, can you just read for the court what you wrote to Ms. Sangalaza?
One moment, are you moving now for its admission?
Oh, I'm sorry. Yes, Your Honor. I move to admit Exhibit 1.
All right. Any other objections?
Yes, Your Honor. This exhibit was already dealt with previous in a different hearing. I mean, I don't understand how, like, what it is they're trying to establish.
I don't know what they're trying to establish either, but the fact that it was attached to a previous proceeding does not prohibit it from being admitted into evidence at this point in time. Generally, I can say that the reason people attach emails and text messages is to show that the parties aren't capable of getting along. But that would be a relevance objection, and what is the relevance of the text messages, Mr. White?
Excuse me, Your Honor. The relevance of the text messages is to establish that essentially shortly after the child's birth, there was a protracted period of withholding of the child from all contact with the plaintiff, as demonstrated by these messages, and then also to establish Ms. Sangalaza's basis that she asserted for that withholding.
All right. The objection is overruled. Foundation has been laid. The exhibits will be admitted.
Okay, so again, Mr. Ravello, if you could read what you wrote to Karen on June 30th.
Can we discuss a time for me to see Julian and what our plans will be for living arrangements, please?
And so why were you asking her that question on that date?
Because I wanted to see my son and figure out where we were going to be living.
At that point, how long had it been since you saw your son?
Weeks.
Was there a response to that message?
No.
Okay. What's the date of the next message that you sent?
Thursday, July 5th.
Okay. And what did you say in that message?
Can we discuss a time for me to visit Jay and establish our living arrangements, please?
Okay. And then, was there a response to that message?
No.
So what was the date of your next message to Karen?
Sunday, July 8th.
Okay.
Objection.
And what?
One moment. What's the objection?
Completely skipped the date.
Right. Again, on Thursday, July 5th, I attached a question mark.
And it's not an objection. You can ask if there are parts of this that Mr. Lytle didn't ask about that you want to bring out.
Okay.
You can do that on your cross, okay?
So, can I answer
Go
that
ahead, Mr.
again?
Lytle.
Yes.
Okay. 2 hours later on July 5th, I sent a question mark.
Okay. And was there a response from Ms. Sangalaza to your question mark?
No.
What was the date of your next communication with?
3 days later, July 8th.
And what did you write to her on that date?
Hi, Karen. Please contact me.
Was there any response to that message?
No.
What was the next communication with Ms. Sangalaza?
2 days later, July 10th, is your phone working?
And was there any response to that message?
No.
So on this page, we've covered a date period from June 30th to July 10th. And you've testified that this was in 2018, correct?
Yes.
Okay. What, did you get any written responses from Karen during that period on any other platforms?
No.
Okay. And did you see Julian at all during that time frame?
No.
Objection.
One moment. What's your objection?
Relevance?
Well, how people get along once the baby was born and prior to the baby's birth is relevant to trying to establish custody, so I'll overrule the objection.
All right. At some point in 2018, did you ask me to file a motion on your behalf?
Objection, leading question.
Foundational overruled.
Yes.
Okay. And what was the objective of that particular motion?
I wanted to see my son. I wasn't seeing him at all.
Okay. Do you remember what the result of the hearing of that motion was?
Objection, leading question.
No, it's asking him what he remembers, so it didn't suggest what the answer is.
I don't remember.
Okay.
Are you asking the first?
Objection, witness already answered the question.
Sustained.
Let's jump back. You're the plaintiff in this action, correct?
Yeah.
Okay. Do you recall when your complaint was filed?
Objection, question was already asked.
No, he didn't actually answer when the complaint was filed, just a general time period when he saw his attorney.
I know I started meeting with you in June. I'm not sure the exact date where it was filed to the court.
If you could take a look at Exhibit 2 in your binder, it's going to be behind that second green page. Just tell me if you recognize that document.
I'm sorry, where's Exhibit 2?
Exhibit 2.
The green page? Okay. All right.
Do you recognize Exhibit 2?
The document?
So there's a green page that says Exhibit 2.
Yeah?
Objection.
Right. So the document immediately behind that, do you recognize that document?
Yes.
Okay, and what is that document?
This is our initial motion.
Can you just read the title of the document?
Objection, he's telling the witness what to say.
He's not telling the witness what to say, however, the document hasn't been admitted into evidence. What is number 2? Is it a filed pleading in the case?
Complaint to establish child paternity, custody, and UCCJEA declaration.
Okay. So is that the complaint that you filed to initiate this case?
Yes.
Okay. And in on the first page, top right corner, do you see a file stamp there?
Yes.
And what was the date of filing?
June 13th, 2018.
Okay. So does
Are you moving to admit number 2, or were you just using it to refresh memory?
I was just using it to refresh recollection.
Exhibit number 2 is a file stamp copy of the complaint, and the court can take judicial notice of any of the pleadings, that is, that it was a pleading filed. All right.
I think you are. So the complaint was filed on June 13th, 2018, correct?
Correct.
Okay. How long after that date did you next see Julian?
Objection, leading question.
It's not leading, ma'am. He asked him how long. He didn't suggest an answer. Overruled.
It was around a month. Yeah, I would say at least a month.
Okay. And
Your Honor, may I respond, please? May I?
When you have your time to testify, you can then
Thank you.
testify as to what you think he doesn't remember or what he said that you don't agree with,
Okay.
but not while he's testifying. Okay, go ahead.
All right, and prior to the filing of that complaint on June 13th, do you recall when was the last time you had seen Julia?
It had been weeks.
How many weeks? 2?
Objection.
One moment.
He's telling the witness, he's leading the local
I'm
witness
just trying to get a little
2
bit more
weeks.
specifics here.
I think that A, it is leading, 2, it's cumulative because he already testified in the context of the text messages, a response to that. So I'll sustain the objection is cumulative.
Okay, I believe you testified earlier that, that Ms. Sangalaza and her parents had left Summerlin Hospital with Julian, correct?
They did.
Okay, so in total, how much time passed between that time and the next time that you saw Julian?
I didn't spend any one-on-one time with my son until he was at least 6 months old.
Okay. Let me get you to turn ahead to Exhibit 5. Do you see Exhibit 5?
Yes,
Do you recognize the document behind that tab?
yes.
And what is that document?
Partial parenting agreement.
Okay, and as you did with the complaint, if you look in the top right corner of that first page, do you see a date there?
November 5th, 2018.
Perfect. Yeah, I guess I'm asking to admit, this exhibit, it is in the record of the case already. As you can see from the file stamp in open court.
Objection? Do you
To-
have proposed exhibit number 5, which is the parenting agreement that was filed with the court?
Yeah, actually, Your Honor, I am going to object to it because the orders that Judge Denise Gentile made, they completely overruled this. Actually, no, they were made by Judge Linda Marquise. They completely wiped out this parenting agreement that we had.
So you're saying it's no longer relevant?
Yeah, she made orders.
Mr. Lytle, what is the relevance?
Yeah, Your Honor, I'm trying to establish a timeline here of contact and when things happen. That's the primary reason for talking about this document. I also want him to confirm the process that led to this agreement and what was agreed to as of November 5th, 2018. With the understanding that obviously that was a year ago and there's more of the story to tell. But I do think it's an important piece of the timeline.
So you believe it's relevant to show the parties' continuing relationships with one another that goes to one of the factors for custody?
I believe
That
it.
is, how they relate to one another or what they agreed to?
I believe it establishes an important part of the timeline, so that we can talk competently about what has happened in the year since this agreement was reached.
All right, so I do find that it has relevancy, even though Judge Gentile and Judge Marquis later, based upon motions filed by the parties entered a different order than that of the partial parenting agreement. Some aspects of it may have continued, some may not have, so, but it's relevant towards the interchange and relationship of the parties that led up to the trial today. So, objection overruled.
Thank you. Okay, if you would, I'm gonna ask you to just go to the last page first, and then we'll go backwards. If you look on the very last page of the document, page 8. See a bunch of signatures on that page?
Yes.
Okay, is your signature on that page?
Yes.
And is the defendant's signature on that page?
Yes.
And it looks like signatures for me and her counsel at the time, is that correct?
Both counsel, yes.
Okay, and what's the date on all those signatures?
November 5, 2018.
Okay. And if you go back to the very first page of the document, and you see a heading that says legal custody provisions.
Yeah.
Okay, can you read the second sentence under that heading?
The parents agree to joint legal custody of the child named above.
And then can you read the following sentence?
The parents agree to provide each other with the names, addresses, and phone numbers of all medical, educational, child care, and other providers of professional services for the child.
If you go to page 2, at the bottom, there's another heading that says timeshare provisions. Do you see that?
Yes.
And it's starting at line 25. Can you read just the first 2 sentences of that second paragraph there?
Yes. The father's timeshare is defined as beginning after the father has concluded his court-ordered infant and newborn care class. The father's timeshare is defined as beginning on the first Monday after December 1st, 2018.
Did you complete the court-ordered infant and newborn care class?
I did.
Did you begin having some visitation with Julian at some point after that?
I did.
Okay. All right. Once that visitation began, what was the arrangement in terms of where and how the child was exchanged?
We would pick the child up when it was our time. My time was Monday through Thursday. 2 of the days were 8-hour visits, 2 of the days were 4-hour visits.
When you say we, who do you mean, sir?
Oh, the child's mother and I. When we did our exchanges,
Oh, okay, I see what you mean.
the picking up parent would go to the other's home
Okay.
to get the child.
So do you recall the address that you were going to for your pickups?
Objection, Your Honor, relevance.
I can see where that would be relevant, so I'll overrule. Go ahead.
I was picking him up from his mother's parents' home on Kappas Drive.
And who to your knowledge resided at that home?
Objection, that question was already answered.
He did say that it was from her mother's home. You want to know who else besides?
Correct.
All right,
To his knowledge, who all
overruled.
lived at that house?
Okay. Besides her parents.
Sure, if anyone.
It was the same lineup I mentioned before, the two parents and the two siblings, Isabel and Barrett.
Did the exchanges, the visitation schedule from November that was agreed to, did that, has that continued without interruption to today?
Objection, leading question.
Overruled.
Has that continued without interruption to this day?
It has been interrupted many times.
Do you recall the approximate date of the first interruption of that schedule?
The first big interruption was after Judge Marquis ordered 50-50 temporary custody.
Objection, Your Honor. So we're only focusing on the partial parenting agreement over here. I mean, how is it that we've already, have we moved from it?
One moment. The objection would technically be non-responsive, but if you want to rephrase the question, Mr. Lytle.
Okay.
Your question said departing from the parenting agreement. His response dealt with something other than the parenting agreement.
Let me just ask you sort of a different foundational question. Have there been any periods since November of 2018 when visitation by you or custodial time by you was denied by the defendant?
Yes,
Okay.
the very first day.
Okay.
She claimed Veterans Day was her holiday, and it was mine that year. So
Objection,
I missed
Your Honor.
visitation the very first day.
Objection, Your Honor.
Go ahead.
So leading question, and then this is, he's pulling things from the air. I mean, there's nothing to back up this claim.
That would go to the weight to be given to his testimony, not whether he can say it. Objection is overruled.
Leaving aside a day here, a day there. Okay, I just want to, sort of a yes or no question, since November of 2018, have there been any sort of extended periods when visitation or your custodial time was denied by the defendant?
Yes.
Okay. And do you recall when the first of those extended periods was?
Yes, the first extended period was the entire months of February and March of this year. 2 straight months.
Your Honor, I'm going to object. Are we still talking about the parenting agreement, or what are we talking about?
No, his question was, putting aside a day here or there, have there been times when, extended period of times when you denied visitation? And that was the question. He's responded to the question. So overruled.
Yes.
You said that was in February or March of this year?
February and March.
February and March. Okay. And what if anything was your response to that interruption of your custodial time? How did you attempt to deal with that?
I was going to pick him up during my ordered times to pick him up. And when he wasn't exchanged, I would call you, my counsel, and I would then contact Metro. And they would come fill out a report card, and I would go home.
At some point, did Metro advise you that, that a protective order had been entered against you?
They did, yeah.
And-
Objection, leading question, and relevance.
I'll sustain it as a leading question.
All right. When Metro would make contact with you at these attempted exchanges, what sorts of things did they tell you?
They would typically,
Objection, hearsay.
Counsel?
Goes to his understanding of what it's just to his state of mind. I'm not introducing this
I'll allow it as to his
as
state of
fact.
mind, not for the truth of the matter. So,
sure, Metro would give me typically a police report card, but one time they did give me news that I'd been served a temporary protective order by her father.
Did Metro facilitate restoring your custodial time?
No,
So what, if anything, did you do next to try to restore your custodial time?
I believe I had my counsel file motions for pickup orders.
Do you recall if the motion for pickup order was heard on the date that it was originally scheduled to be heard?
Objection, leading question.
it's not leading, it doesn't to suggest an answer, so, and it's foundational overruled.
Can you say it again, please?
So you said you had instructed me to file a motion for pickup order, correct?
Mhm.
Okay. And was that motion then set for a hearing date?
Well, I think the temporary protective order filed by her father precluded that.
Objection, witness didn't answer the question that was asked.
I'm just asking if it was set.
Sustained.
It's non-responsive. I'm just asking if it was set, leaving aside the TPO, or just talking about the motion for pickup order, was that set for a hearing in family court?
I believe so.
Okay. And do you recall if that motion was heard on the date that it was initially scheduled to be heard by Judge Marquis?
I believe,
If you don't remember, just say you don't remember, sir.
yeah, I don't remember specifically the first pickup order, the result.
Do you recall if, after the filing of that motion for pickup order, do you recall whether Ms. Sangalaza filed anything with the court?
Yeah, she filed a motion to disqualify the judge based on discrimination and bias.
Okay. And do you recall what if anything, resulted from her filing of that affidavit
Objection.
of disqualification?
Leading question.
It was not a leading question. The court records are the court records, Mr. Little.
Correct.
What's the point of the question? The motion to disqualify was heard by the chief judge. The chief judge denied the motion.
Correct, which resulted in a significant delay to the hearing of the pickup order, which is,
And you can make that argument asking me to take judicial notice of the records
I'll do
because
that. I'll
I
do
don't
that, Your
think
Honor.
your client is gonna be able to
That's fine.
come up with information
No problem.
specifically as to each of these.
No problem. Well, let me just ask you this then. At some point,